Jan Logie.
Thank you, Mr. Chair. And at this stage of the debate, I'd like to speak to all three of the SOPs that are on the table, and specifically to speak to the Minister's SOP 188 first, and to reference the Minister's comments in reference to my SOPs earlier in the evening. The Minister's SOP that the Green Party will be voting against because it seeks to extend the periodic review of the operation of this Act. And this Act is incredibly important for justice for victims of sexual violence and domestic violence. And that in this country we have had many pieces of work trying to reform, telling us what we need to do to reform our justice system. And we know that there's about a 1% conviction rate for sexual violence in this country and about 2% for domestic violence. And a significant part of the reason that that conviction rate is so low is about our justice system and our courts and how they're operating. When we've got a body of academic work where there have been interviews with lawyers and judges have said if a family member of theirs was raped, they would not advise them to go to the police and take a case to court because they would not want to see their loved ones re-traumatised through the court process. And we've had many recommendations telling us what we should do to fix the system to stop that reality, to enable victims of sexual violence to achieve justice. And as a consequence of that, for us all to be safer as a society when people are held properly to account. And yet we haven't managed to get those changes through our system. We had the Law Commission work on alternative trials and pre-trial processes initiated in 2009, and that was taken off the table by the last term's Justice Minister, Judith Collins, and put back on by this current Minister of Justice, Amy Adams. But the problem was she gave the Law Commission a very short time frame for considering the work, which reduced the scope of what they were able to consider in that review. That review reported back in December last year, and one of their recommendations was that there needed to be further consideration to reviewing the substantive rules of evidence, the exact content of this piece of legislation in front of us at the moment, and that they suggested that could take place at the same time as the next review of the Evidence Act, which is now being extended by this SOP put forward by the government. So we have had case after case going through our courts that have just broken the hearts of women and men around the country who have looked on and gone, that is unfair, that is wrong, that somebody should be subjected to that experience in the process of trying to get justice. And we have had a massive piece of academic work called From Real Rape to Real Justice, done by Elizabeth McDonald and Yvette Tinsley from Victoria University, that has told us what we need to be considering. Some of that work only went into the Law Commission's review, some of it was put aside. And then that work got shrunk down, and then one of their conclusions was, well, we need to be looking at the Evidence Act. And now the time frame for that is being put out again. It is actually completely unacceptable. We heard from the Minister earlier this evening that, well, they can't support the SOPs I've put forward because, well, the government's looking at these issues in a considered way and they're very complex issues. This has been going on since before 2009, where the solutions and the issues have been put on the table since 2009. This is 7 years of victims of sexual violence in this country waiting for us to do our job, to give them a system that has a hope of giving them some dignity in the process of trying to achieve justice. It is not acceptable that this House would extend that process any further. We have the chance to actually prioritise this, Mr. Chair.
Logie.
And I will just calm myself at this moment and try and bring it back to the SOPs that we have put forward, which are tiny tinkerings to the system. But they are systems and things that we could do in the form of an amendment to this Act that could make a small change. And so one of those things, which was recommended by Elizabeth MacDonald in her submission, was to be able to allow the alternative ways of giving evidence, which has been created in this legislation for children, to make that the presumption for victims of sexual violence and domestic violence. And the Minister noted that in her response to this, she was saying, while they support the intent of my SOPs, that this was an incredibly complex area and there's different vulnerabilities for adults and they need different solutions. Well, I would like to point out to the Minister that the latest report from the Law Commission that came forward in December said that less traumatic methods of giving evidence at trial should be made available to complainants of sexual violence. That is what my SOP does. And I will also note that the Minister also said that we can't, that providing evidence by CCTV won't solve it all. No, it won't. I really, really wish the Select Committee could have been given a bill that would have enabled them to consider all the issues to make a real difference. But this is one thing that could. And the ongoing research noted by Elizabeth MacDonald still indicates that there is an inconsistent approach to the issue of support and advice to adult complainants in sexual cases. And a presumption would address this issue. There is no evidence to suggest that this has changed as a matter of practice, nor has there been any responsive amendment to the Victims of Crime Guidance to Prosecutors guidance. And the adult complainants who have made allegations of childhood sexual abuse may also be, and this has been recognised by our courts, extremely vulnerable and require assistance to give evidence. And yet the government or the committee chose not to recommend those changes to this House. So my SOP rectifies that oversight and gives this House the opportunity tonight to ensure that sexual violence victims have that presumption to give evidence in alternative ways. It doesn't lock them into it. They can still opt out of it and provide evidence in other ways. This has been recommended by the Law Commission. It is supported, the need for it is supported by long-standing research, and this House should do that. Victims of sexual violence in this country deserve us to give that to them. The other recommendation that I make is again incredibly minor in the SOP, which is to ensure or to provide, excuse me just while I find my piece of paper, that intimidating evidence, that we add intimidating to a list of unacceptable questions that a judge may disallow or direct that a witness may not be obliged to answer. And the point of this, while the judges currently do have discretion, and that's been the argument against putting this, the advice and the suggestion from Elizabeth MacDonald for including it in the list is more about the signal that it will send to victims. That victims will know that intimidating evidence is not considered appropriate in our courts. And that actually may help build that confidence in our court systems to help victims of sexual violence come forward and use the system in the hope of getting justice. We know we can't assure them of that at the moment, and we know that actually when we've seen a very recent case where I would say some evidence that was allowed was completely, and lines of questioning were completely unacceptable, I think there needs to be clearer direction for the court and also clearer message of what victims can expect. So on that note, I'll be interested in hearing responses.
Jackie Dean.
Mr. Chair,